Welcome to Primary Sources. I'm Jason Beats. This week, I will read and discuss the Supreme Court's decision that overturned the eviction moratorium issued by the Centers for Disease Control and Prevention. The CDC issued the moratorium as an emergency measure to reduce the spread of COVID-19. The Supreme Court's decision concerned whether a statute, which granted powers to the CDC to prevent the spread of disease, allowed the agency to authorize an eviction moratorium on its own. The Supreme Court decided the CDC lacked the legal authority to create the moratorium. The three liberals on the court disagreed and joined Justice Breyer's dissent. The Supreme Court issued its decision on its shadow docket, a mix of emergency motions and other expedited cases that haven't received full briefing or oral argument. I will read the Supreme Court decision and Breyer's dissent. Afterward, I will analyze the eviction moratorium before providing my thoughts on the policy and the court's decision. Supreme Court of the United States. Alabama Association of Realtors et al., the Department of Health and Human Services et al., on application to vacate stay, August 26, 2021. Per curiam. The Director of the Centers for Disease Control and Prevention, CDC, has imposed a nationwide moratorium on evictions of any tenants who live in a county that is experiencing substantial or high levels of COVID-19 transmission, and to make certain declarations of financial need. The Alabama Association of Realtors, along with other plaintiffs, obtained a judgment from the U.S. District Court for the District of Columbia, vacating the moratorium on the ground that it is unlawful. But the District Court stayed its judgment while the government pursued an appeal. We vacate that stay, rendering the judgment enforceable. The District Court produced a comprehensive opinion, concluding that the statute on which the CDC relies does not grant it the authority it claims. The case has been thoroughly briefed before us, twice, and careful review of that record makes clear that the applicants are virtually certain to succeed on the merits of their argument that the CDC has exceeded its authority. It would be one thing if Congress had specifically authorized the action the CDC has taken, but that has not happened. Instead, the CDC has imposed a nationwide moratorium on evictions in reliance on a decades-old statute that authorizes it to implement measures like fumigation and pest extermination. It strains credulity to believe that the statute grants the CDC the sweeping authority that it asserts. In March 2020, Congress passed the Coronavirus Aid, Relief, and Economic Security Act to alleviate burdens caused by the burgeoning COVID-19 pandemic. Among other relief programs, the Act imposed a 120-day eviction moratorium for properties that participated in federal assistance programs or were subject to federally backed loans. When the eviction moratorium expired in July, Congress did not renew it. Concluding that further action was needed, the CDC decided to do what Congress had not. The new administratively imposed moratorium went further than its statutory predecessor, covering all residential properties nationwide and imposing criminal penalties on violators. The CDC's moratorium was originally slated to expire on December 31, 2020, but Congress extended it for 1 month as part of the second COVID-19 Relief Act. See Consolidated Appropriations Act 2021. As the new deadline approached, the CDC again took matters into its own hands, extending its moratorium through March, then again through June, and ultimately through July. The CDC relied on Section 361A of the Public Health Service Act for authority to promulgate and extend the eviction moratorium. The provision states, "The Surgeon General, with the approval of the Secretary of Health and Human Services, is authorized to make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into any other state or possession. For purposes of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary." See also 42 CFR Section 70.2, 2020, delegating this authority to the CDC. Originally passed in 1944, This provision has rarely been invoked, and never before to justify an eviction moratorium. Regulations under this authority have generally been limited to quarantining infected individuals and prohibiting the import or sale of animals known to transmit disease. CEG 40 Fed Reg 22543, 1975, banning small turtles known to be carriers of Salmonella. Realtor associations and rental property managers in Alabama and Georgia sued to enjoin the CDC's moratorium. The U.S. District Court for the District of Columbia granted the plaintiffs' summary judgment, holding the CDC lacked statutory authority to impose the moratorium. Alabama Association of Realtors, the Department of Health and Human Services, May 5, 2021. But the court stayed its order pending appeal. It reasoned that even though the government had not shown a substantial likelihood of success, it did make a lesser showing of a serious legal question on the merits, which the court said warranted granting a stay when the remaining stay factors weighed in the government's favor. May 14, 2021. See also Enkin v. Holder, 2009, listing the 4 traditional stay factors. 1. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2. Whether the applicant will be irreparably injured absent a stay. 3. Whether issuance of the stay will substantially injure the other parties interested in the proceeding. And 4. Where the public interest lies. The D.C. Circuit agreed, though it rated the government's arguments more highly. June 2, 2021. This court declined to vacate the stay. Justice Kavanaugh concurred, explaining that he agreed with the district court that the CDC's moratorium exceeded its statutory authority. But because the CDC planned to end the moratorium in only a few weeks, and because that time would allow for additional and more orderly distribution of congressionally appropriated rental assistance funds, he concluded that the balance of equities justified leaving the stay in place. Justices Thomas, Alito, Gorsuch, and Barrett noted that they would vacate the stay. The moratorium expired on July 31, 2021. 3 days later, the CDC reimposed it. Apart from slightly narrowing the geographic scope, the new moratorium is indistinguishable from the old. With the moratorium once again in place, the plaintiffs returned to the district court to seek vacatur of its stay. The district court agreed with the plaintiffs that the stay was no longer warranted for 2 reasons. First, the government was unlikely to succeed on the merits, given the 4 votes to vacate the stay in this court and Justice Kavanaugh's concurring opinion. Second, the equities had shifted in the plaintiffs' favor. Vaccine and rental assistance distribution had improved since the stay was entered, while the harm to landlords had continued to increase. But the court concluded that its hands were tied by the law of the case, in light of the D.C. Circuit's earlier decision not to vacate the stay. That denial was followed by one more stop at the D.C. Circuit, where the court again declined to lift the stay. Having passed through the lower courts twice, the plaintiffs returned as applicants to this court to again ask us to vacate the district court's stay. The district court concluded that its stay is no longer justified under the governing 4-factor test. See Enkin v. Holder, Supra, at 434. We agree. The applicants not only have a substantial likelihood of success on the merits, it is difficult to imagine them losing. The government contends that the first sentence of Section 361A gives the CDC broad authority to take whatever measures it deems necessary to control the spread of COVID-19, including issuing the moratorium. But the second sentence informs the grant of authority by illustrating the kinds of measures that could be necessary: inspection, fumigation, disinfection, sanitation, pest extermination, and destruction of contaminated animals and articles. These measures directly relate to preventing the interstate spread of disease by identifying, isolating, and destroying the disease itself. The CDC's moratorium, on the other hand, relates to interstate infection far more indirectly. If evictions occur, some subset of tenants might move from one state to another, and some subset of that group might do so while infected with COVID-19. This downstream connection between eviction and the interstate spread of disease is markedly different from the direct targeting of disease that characterizes the measures identified in the statute. Reading both sentences together, rather than the first in isolation, it is a stretch to maintain that Section 361A gives the CDC the authority to impose this eviction moratorium. Even if the text were ambiguous, the sheer scope of CDC's claimed authority under Section 361A would counsel against the government's interpretation. We expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. Utility Air Regulatory Group v. EPA, 2014, quoting FDA v. Brown and Williamson Tobacco Corporation, 2000. That is exactly the kind of power that the CDC claims here. At least 80% of the country, including between 6 and 17 million tenants at risk of eviction, falls within the moratorium. While the parties dispute the financial burden on landlords, Congress has provided nearly $50 billion in emergency rental assistance, a reasonable proxy of the moratorium's economic impact. And the issues at stake are not merely financial. The moratorium intrudes into an area that is the particular domain of state law, the landlord-tenant relationship. See Lindsay v. Normett, 1972. Our precedents require Congress to enact exceedingly clear language if it wishes to significantly alter the balance between federal and state power and the power of the government over private property. United States Forest Service v. Calpasture River Preservation Association, 2020. Indeed, the government's read of Section 361A would give the CDC a breathtaking amount of authority. It is hard to see what measures this interpretation would place outside the CDC's reach, and the government has identified no limit in Section 361A beyond the requirement that the CDC deem a measure necessary. Could the CDC, for example, mandate free grocery delivery to the homes of the sick or vulnerable? Require manufacturers to provide free computers to enable people to work from home? Order telecommunications companies to provide free high-speed internet service to facilitate remote work? This claim of expansive authority under Section 361A is unprecedented. Since that provision's enactment in 1944, no regulation premised on it has even begun to approach the size or scope of the eviction moratorium. And it is further amplified by the CDC's decision to impose criminal penalties of up to a $250,000 fine and 1 year in jail on those who violate the moratorium. Section 361A is a wafer-thin reed on which to rest such sweeping power. The equities do not justify depriving the applicants of the district court's judgment in their favor. The moratorium has put the applicants, along with millions of landlords across the country, at risk of irreparable harm by depriving them of rent payments with no guarantee of eventual recovery. Despite the CDC's determination that landlords should bear a significant financial cost of the pandemic, many landlords have modest means, and preventing them from evicting tenants who breach their leases intrudes on one of the most fundamental elements of property ownership, the right to exclude. See Loretto v. Teleprompter Manhattan CATV Corps, 1982. As harm to the applicants has increased, the government's interests have decreased. Since the district court entered its stay, the government has had 3 additional months to distribute rental assistance funds to help ease the transition away from the moratorium. Whatever interest the government had in maintaining the moratorium's original end date to ensure the orderly administration of those programs has since diminished. And Congress was on notice that a further extension would almost surely require new legislation, yet it failed to act in the several weeks leading up to the moratorium's expiration. It is indisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant. But our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. Youngstown Sheet and Tube Company v. Sawyer, 1952, concluding that even the government's belief that its action was necessary to avert a national catastrophe could not overcome a lack of congressional authorization. It is up to Congress, not the CDC, to decide whether the public interest merits further action here. If a federally imposed eviction moratorium is to continue, Congress must specifically authorize it. The application to vacate stay presented to the Chief Justice and by him referred to this court is granted. So ordered. Next, we'll turn to the dissent written by Justice Breyer. Justice Breyer, with whom Justice Sotomayor and Justice Kagan join, dissenting. The Centers for Disease Control and Prevention has issued an order that, in light of the rise of the COVID-19 Delta variant, temporarily prohibits certain evictions in high transmission counties through October 3rd. Today, this court, as an emergency matter, without full briefing or argument, blocks that order by vacating a lower court stay. I think the court is wrong to do so, and I dissent. We may not vacate a stay entered by a lower court unless that court clearly and demonstrably erred in its application of accepted standards. Planned Parenthood of Greater Texas Surgical Health Services, v. Abbott, 2013. Those accepted factors are: 1. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2. Whether the applicant will be irreparably injured absent a stay. 3. Whether the issuance of the stay will substantially injure the other parties interested in the proceeding. And 4. Where the public interest lies. Enkin v. Holder, 2009. In my view, the courts below did not clearly err for 3 reasons. First, it is far from demonstrably clear that the CDC lacks the power to issue its modified moratorium order. The CDC's current order is substantially more tailored than its prior eviction moratorium, which automatically applied nationwide. Justified by the Delta variant surge, the modified order targets only those regions currently experiencing skyrocketing rates. If a covered county no longer experiences substantial or high levels of community transmission, the order will no longer apply there. To illustrate the difference, when we denied applicants' last motion, fewer than 20% of counties would have been covered under the modified moratorium order's criteria. Today, however, that figure is over 90%. To be protected from eviction, the tenant must reside in a covered area and attest that he or she 1. Has used best efforts to obtain all available governmental assistance for renter housing. 2. Satisfies certain income requirements. 3. Is unable to pay rent due to substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. 4. Continues to use best efforts to make timely partial rent payments that are as close to the full rent payment as permitted. And 5. Has no other available housing options. Unlike under New York's moratorium, landlords remain free to challenge in court the truthfulness of a tenant's declaration that he or she qualifies for the order's protection. The CDC issued this modified moratorium order, like its prior moratorium order, pursuant to its powers under Section 361A of the Public Health Service Act. That provision authorizes the CDC to make and enforce such regulations as in its judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases interstate. For purposes of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures, as in his judgment may be necessary. The statute's first sentence grants the CDC authority to design measures that, in the agency's judgment, are essential to contain disease outbreaks. The provision's plain meaning includes eviction moratoria necessary to stop the spread of diseases like COVID-19. When Congress enacted Section 361A, public health agencies intervened in the housing market by regulation, including eviction moratoria, to contain infection by preventing the movement of people. CEG 5,589 new cases in one day break influenza record. New York Times, January 29, 1920. The Health Department instructs all landlords that no person suffering from influenza and pneumonia can be removed under any condition whatever without the sanction of the Health Department. If Congress had meant to exclude these types of measures from its broad grant of authority, it likely would have said so. Section 361A's second sentence is naturally read to expand the agency's power by providing congressional authorization to act on personal property when necessary. See FTC v. American Tobacco Company, 1924. It could also be read to provide emphasis regarding particular enforcement measures. See Ali v. Federal Bureau of Prisons, 2008. Applicants urge, and today's per curiam agrees, that the second sentence should instead be read to cabin the CDC's authority. Not only does that reading lack a clear statutory basis, but the second sentence goes on to empower the CDC to take other measures as in its judgment may be necessary. Furthermore, reading the provision's second sentence to narrow the first would undermine Congress's purpose. As a key drafter explained, the second sentence of subsection A was written not to limit the broad authority contained in the first sentence, but to expressly authorize inspections and other steps necessary in the enforcement of quarantine. Hearings on H.R. 3379 before the subcommittee of the Committee on Interstate and Foreign Commerce, 1944. The per curiam also says that Congress must speak more clearly to authorize the CDC to address public health crises via eviction moratoria. But it is undisputed that the statute permits the CDC to adopt significant measures such as quarantines, which arguably impose greater restrictions on individuals' rights and state police powers than do limits on evictions. Indeed, the current Congress did not bristle at the government's reading of the statute. In 2020, Congress extended the moratorium, quote, issued under Section 361 of the Public Health Service Act, Consolidated Appropriations Act 2021. In any event, lower courts have split on this question. Compare Alabama Association of Realtors v. Department of Health and Human Services, June 2, 2021, with Tiger Lily LLC v. United States Department of Housing and Urban Development, also 2021. Given the split among the circuits, it is at least hard to say that the government's reading of the statute is demonstrably wrong. See Coleman v. Packer, Inc., 1976. At minimum, there are arguments on both sides. Certainly, this court did not resolve the question by denying the applicant's last emergency motion, whatever one justice might have said in a concurrence. The scope of that challenged moratorium, the balance of the equities, and the public interest were all different. As is typical in this court's emergency orders denying extraordinary relief, we said almost nothing about our reasons for declining to act. Second, the balance of equities strongly favors leaving the stay in place. Applicants say they have lost thousands of dollars in rental income. That injury is lessened by the moratorium's orders directive that tenants have an obligation to make as close to the full rental payment as possible. And to compensate for the shortfall, Congress has appropriated more than $46.5 billion to help pay rent and rental arrears. It may, as applicants say, take time to get that money, and that is an injury. But compare that injury to the irreparable harm from vacating the stay. COVID-19 transmission rates have spiked in recent weeks, reaching levels that the CDC puts as high as last winter, 150,000 new cases per day. To date, the CDC estimates 38,150,911 Americans have been sickened. 629,139 have died. This week, the CDC calculates average new daily hospital admissions at 12,209. The number of patients hospitalized with COVID-19 is up 13.3% from last week. Look back at the order's criteria for temporary eviction relief. The CDC targets only those people who have nowhere else to live, in areas with dangerous levels of community transmission. These people may end up with relatives in shelters or seeking beds in other congregate facilities, where the doubly contagious Delta variant threatens to spread quickly. See CDC Delta variant, What We Know About the Science. Delta variant is, quote, more than 2 times as contagious as previous variants, and may cause more severe illness than previous strains in unvaccinated persons. Absent the current stay, the CDC projects a strong likelihood of mass evictions nationwide, with public health consequences that would be difficult to reverse. Third, the public interest is not favored by the spread of disease or a court's second-guessing of the CDC's judgment. The CDC has determined that a surge in evictions could lead to the immediate and significant movement of large numbers of persons from lower density to higher density housing, when the highly transmissible Delta variant is driving COVID-19 cases at an unprecedented rate. The CDC cites models showing up to a 30% increased risk of contracting COVID-19 for some evicted people and those who share housing with them after displacement. The CDC invokes studies finding nationally over 433,000 cases and over 10,000 deaths may be traced to the lifting of state eviction moratoria. The public interest strongly favors respecting the CDC's judgment at this moment, when over 90% of counties are experiencing high transmission rates. That figure is the highest it has been since at least last winter. It was in the single digits when we considered the CDC's previous moratorium order and denied applicants' earlier motion. On applicants' last trip to this court, they argued that the downward trend in COVID-19 cases and the effectiveness of vaccines left no public health rationale for the CDC's then operative eviction moratorium. These predictions have proved tragically untrue. Today they show just how little we may presume to know about the course of this pandemic. Applicants raise contested legal questions about an important federal statute on which the lower courts are split and on which this court has never actually spoken. These questions call for considered decision-making, informed by full briefing and argument. Their answers impact the health of millions. We should not set aside the CDC's eviction moratorium in this summary proceeding. The criteria for granting the emergency application are not met. I respectfully dissent. Now, I will provide some context on the eviction moratorium. Congresswoman Cori, a progressive from Missouri, pressured the Biden administration to issue its most recent eviction moratorium by staging a sit-in in front of the U.S. Capitol building. Bush was passionate about the issue because she had previously been evicted herself. The Biden administration is disappointed the federal government hasn't distributed the rental assistance approved by Congress as quickly as the administration had hoped. 2 federal pandemic relief laws that authorized rental assistance were signed in December 2020 and March 2021. 11% of the $46.5 billion in rental assistance has been distributed, according to a New York Times article written in late August. The rental assistance was designed to be spent over 3 years, but the Biden administration hoped the states would have distributed the money more quickly. Biden administration officials are working with state and local officials to try to speed up the distribution of rental assistance. The Kansas Emergency Rental Assistance Program provides rental assistance to Kansans experiencing financial hardship as a result of the COVID pandemic. To qualify for assistance, applicants must meet the following criteria. Tenants must rent their home. The tenant's 2020 household income cannot exceed 80% of their area's median income. At least one member of the tenant's household must experience documented financial hardship as a result of the COVID pandemic. Hardship may include loss of employment, reduction in household income, or significant COVID-related expenses, such as medical bills, childcare costs, or internet costs to enable working or attending school from home. At least one member of the household must be uncertain where they will stay or face the possibility of becoming homeless without housing assistance. Applicants must also provide proof of identity. To qualify, applicants must not have received assistance from other sources for the same costs and time period for which they are requesting assistance from the Kansas Emergency Rental Assistance Program. Landlords and tenants must complete the application together, and they may do so by filling out a form available on a website listed in the description of this video. Next, I will provide my thoughts on the eviction moratorium. As a general matter, I support the right of landlords to evict tenants who don't pay their rent. But during a serious respiratory pandemic, I believe an eviction moratorium is appropriate to reduce the spread of a deadly disease. During the COVID-19 pandemic, Congress twice approved an eviction moratorium, indicating congressional support for that type of response from the federal government. I believe the statute invoked by the CDC to defend the executive branch moratorium can reasonably be read in a broad way to authorize the agency to prohibit evictions. The agency's policy appeared to be narrowly tailored and only applied to places that had a substantial or high level of community spread of the coronavirus. I understand the Supreme Court majority's concern with a statute that could potentially be read to authorize expansive and potentially tyrannical government powers to prevent the spread of disease. But the value of an eviction moratorium during a serious respiratory pandemic is considerable. We find ourselves in the middle of a genuine emergency, even though it has persisted for a year and a half. I agree with the dissent written by Justice Breyer and joined by Justices Sotomayor and Kagan. I believe current law should be read to allow the CDC to issue its eviction moratorium as an emergency measure. But a majority of the Supreme Court disagreed and ruled the CDC lacks the authority to issue the moratorium on its own. The majority's opinion comes from a reasonable place, even though I would have reached a different conclusion. Now that the Supreme Court has prevented the CDC from unilaterally issuing an eviction moratorium, the ball is once again in Congress's court. I believe Congress should approve a law that explicitly grants the CDC authority to issue eviction moratoriums to prevent the spread of disease. Alternatively, Congress could approve an eviction moratorium itself and grant the CDC authority to determine the duration of the moratorium. This moratorium, like the one struck down by the Supreme Court, should only apply in places that have substantial or high levels of community spread of coronavirus. A congressional moratorium that lasts only a few months would almost certainly be inadequate for a pandemic that has already lasted much longer than that. Regardless of what Congress decides, I encourage anyone who needs assistance to apply for rental assistance that has already been approved by Congress. That concludes this episode of Primary Sources. Join me next time as we continue to examine the primary sources behind today's top stories.